Hi, everyone. Thank you so much for joining our webinar, Lessons Learned from FCRA Litigation, What Case Law Teaches Employers to Stay Compliant. This webinar is brought to you by Orange Tree Employment Screening and will be hosted by Heidi Seaton, Orange Tree's VP of Legal and Compliance. Heidi has been in the background screening industry for 18 years and has been at Orange Tree for close to 10 years. After the presentation, if there is time, Heidi will be available to answer compliance questions and to continue the conversation. If you could please raise your hand through the GoToWebinar, and we will be sure to unmute you to ask your question. Thank you so much for joining us, Heidi.
Thank you, Suzanne. So again, welcome to everyone. Thank you so much for joining us for this discussion. As Suzanne said, my name is Heidi Seaton. I'm responsible for compliance here at Orange Tree. And so I'm looking forward to talking to the group about, frankly, mostly we're going to be talking about Spokeo and the Spokeo case and what's evolved after Spokeo, because that's really where class actions are happening. So it's very much of interest, I think, to employers, or it should be. So we're going to talk about what is Spokeo again, what's been happening since Spokeo, and then I'll have some thoughts for things I think employers should be spending time on or thinking about. So getting right into it, actually before I get into anything, a reminder, I'm not your lawyer. This is not legal advice. I always urge people to seek the advice of their own legal counsel for any matter relating to employment law, screening law, any sort of, we're also going to be talking about consumer protection laws today. So please do that if you have any questions. So getting into it, Spokeo, what's the background? What is Spokeo? Well, it's simple. Spokeo Inc. is a website. It's basically a people search engine. So you go to the site, you type in a name, you get a report about that person. You'll likely get information about the person's age and where they are and an email address, but you could also get information about marital status, level of education, maybe even information about their income. More specifically, the Spokeo case that we're going to talk about, actually it started out as Robbins v. Spokeo, but because of all of the appeals, it's now Spokeo v. Robbins. Turns out to be all about constitutional Article 3 standing. So one of the minimum requirements to have a case heard in a U.S. federal court. So what does this have to do with background screening? Well, it's actually quite related because in some of its early ads and online materials, the Spokeo website made reference to employers using their products to help them make hiring decisions. That's what really brings this case into the realm of the Fair Credit Reporting Act. And if you've worked with Orange Tree before, or if you've done any background screening, hopefully by now you've heard, the Fair Credit Reporting Act applies in the employment context when a consumer reporting agency, that's a third party like Orange Tree, or in this case, Spokeo, creates a report. And the report, by the way, doesn't have to be written. It can be written, it can be oral, it could be communicated in some other way. But where that report has some sort of bearing on a consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. So again, a reminder for those of you that maybe haven't thought about the Fair Credit Reporting Act lately, it's much more broad than its title would imply. It applies to not just credit reports, but any consumer reports. So it's well established, by the way, that in the employment context, this includes what you might traditionally think of as a background screening report. So there was a question, by the way, early on about whether the reports that Spokeo created were actually consumer reports, whether the Fair Credit Reporting Act applied. On their website, Spokeo had actually explicitly disclaimed that. They said, we're not a consumer reporting agency, our reports are not consumer reports, and in the fine print they said, our reports shouldn't be used for an employment purpose. The question of whether or not Spokeo was a consumer reporting agency, was actually the topic of a Federal Trade Commission enforcement action against Spokeo very early on. And the FTC basically said, the information that Spokeo collects and stores and sells in their profile includes information you might expect to find in a consumer report. It's being marketed for a purpose that's defined in the Fair Credit Reporting Act, employment here. And so it's a consumer report. Basically, they use the reasoning of if it walks like a duck and quacks like a duck, it's probably a duck, right? So they said, yep, it's a consumer report. Anyway, why does this matter? Well, the Fair Credit Reporting Act requires consumer reporting agencies, background screening companies, to follow reasonable procedures to assure maximum possible accuracy of the reports. And it imposes liability on people who willfully fail to comply with those requirements, with the requirements of that act. So under the Fair Credit Reporting Act, a party that doesn't comply with the Fair Credit Reporting Act is liable to the person about whom they are not keeping an accurate report for, among other things, actual damages, statutory damages of $100 to $1,000 per violation, costs, and attorney's fees. In the Spokeo case, Robbins had alleged that Spokeo had willfully violated the Fair Credit Reporting Act, right, which brings that statutory damages calculation by failing to follow reasonable procedures to ensure the accuracy of the information it had about him. Apparently, his report indicated that he was somewhat wealthy, that he had an advanced degree, that he was employed in a professional field. All of these actually positive things, potentially, but just not true. They also got his age wrong. And he alleged that Spokeo's violation had harmed his employment prospects while he was unemployed, causing him ongoing anxiety and stress. So note there, because it'll be important later, that he didn't plead that any employer had failed to hire him because of the report. In fact, he didn't even plead that any particular employer had ever seen his Spokeo profile. And then the other important thing about the Spokeo case is that he brought the suit as a purported class action. So a class action is one where a case is filed on behalf of a large group of plaintiffs. So the named plaintiff, in this case Robbins, was claiming that all of the class members had suffered a similar injury because of Spokeo's wrongful act, this failure to have accurate information in their files about him. And going back to the discussion about damages clause, because that clause allows for damages of $100 to $1,000 per violation, the damages amounts in these sorts of litigation or class cases multiplies by the number of individuals in the class, not to mention the additional costs and fees. So they become very high amount cases. So then getting into the actual history of the case, because it went up and down a few times, it was first heard by the district court for the Central District of California. That's a federal court. Spokeo brought a motion dismissing the case for lack of Article 3 standing. And their analysis said, when asserting a statutory violation, right, like the defendant did something that did not meet the requirements of the statute, the plaintiff must allege the Article 3 minimum of injury in fact. So they said a procedural violation of the Fair Credit Reporting Act without an actualized injury was not sufficient. And Robbins had failed to allege any injury that was in fact caused by Spokeo. Robbins appealed. It went up to the U.S. Court of Appeals for the Ninth Circuit, and the Ninth Circuit reversed. They said their holding was a violation of a statutory right is usually actually a sufficient injury within Article 3 limits, and those limits are respected in this case because Spokeo violated Robbins' statutory rights, not just the statutory rights of other people. So they said it was particular to Robbins, and thus standing was sufficient. So wait, now we're talking about background screening in the FCRA. What does this have to do with standing, right? This is a legal concept. Well, so turns out standing is a really big deal in US federal courts. It's a constitutional requirement. It goes all the way back to the Constitution, up to the Constitution. It's Article 3. And basically the idea is that in order for a court to hear a case, a federal court to hear a case, the individual bringing the suit must have standing to bring it. It's fundamental, and without showing that standing, the courts will throw out the suit and refuse to hear it. There's a few other requirements of Article 3 standing, but they weren't an issue that's for this case, so I'm not going to torch you through them. But the thing that was at issue here is that Article 3 of the Constitution limits the courts to adjudicating only cases and controversies. So the concept of standing requires a plaintiff to show that they have suffered an injury in fact, right? They have to have an injury in order for it to actually be a case or a controversy. And an injury in fact is one where the injury is both concrete and particularized and actual or imminent. So without an injury in fact, there's no case or controversy, and courts will stay out of the case. Going back to our history here then, the district court had said basically, this is just a procedural violation. The plaintiff hasn't actually been injured by this violation. There's no injury in fact, so that's why they said there was no standing. And going back to the circuit court decision here where they reversed, they said, no, well, a violation of a statutory right is in fact an injury itself because it's a denial of a right that was provided by Congress, right? Congress enacted this statute and they included a private cause of action. The Ninth Circuit said that in itself is a failure to provide what's a right under that statute is in itself an injury. And they also said, and by the way, it's also individual to him. It's not just, it's not just an injury to a potential group of people. It was an injury to him. So that's why the Ninth Circuit reversed on the standing issue. So Spokeo, of course, appealed, and so that went up to the U.S. Supreme Court. And the U.S. Supreme Court then vacated and remanded. So the U.S. Supreme Court majority opinion, it was an opinion authored by Justice Alito, vacated that holding, that Ninth Circuit holding, and remanded the case back to the Ninth to be reconsidered. And the Supreme Court said basically, hey, Ninth Circuit, you missed a step. An injury in fact analysis was incomplete. They said a showing of injury in fact requires that a plaintiff show they've suffered an invasion of a legally protected interest that's concrete and particularized. And they said the Ninth Circuit, while they had established that the injury was particular, right? They said it was an injury particular to Robbins. They hadn't done any analysis or showed that they had considered whether or not the injury was concrete. And they said the Ninth Circuit's analysis for concreteness was missing two things. One, they'd failed to analyze whether their injury was de facto. That is, a de facto just means that it actually existed, that there was an actual injury that existed. And two, that the Ninth had failed to address whether the alleged procedural violation entailed a degree of risk sufficient to meet the concreteness requirement. A little bit circular, I know. But maybe it might help a little bit if we talk about what's this degree of risk analysis that they laid out. Actually, it turns out it doesn't help a whole lot, but they did provide some clarification. They said, a degree of risk could be a concrete injury, right? It could just be, something that is tangible, something that can be measured. But it could also be an intangible injury. And then they gave a couple of examples. They gave an example of an intangible injury of being something like if a consumer reporting agency had information about the consumer and everything they had was correct except they had a wrong zip code. They said that would not be a tangible injury. but they said there could be cases where an intangible could be concrete enough. And then they clarified too that a plaintiff doesn't just automatically satisfy the injury in fact requirement whenever a statute grants a right and purports to authorize a suit. They said R3 standing really requires a concrete injury, even in the context of a statutory violation. A violation of a procedural right can be sufficient in some cases, but some procedure violations, they said, are not a risk of real harm, and that was when they provided that incorrect zip code example. But they did say, by the way, we think it's really clear that Congress plainly sought with this Fair Credit Reporting Act to cure the dissemination of incorrect information by adopting procedures designed to decrease that risk. And though that Robbins couldn't satisfy the demands of Article 3 just by alleging a bare procedural violation. So clear as mud. Yes, I know. So then the vacated and remanded meant they provided this opinion, and then the case was sent back down to the Ninth Circuit to reconsider. So the Court of Appeals for the Ninth Circuit on remand, not surprisingly, found that Spokeo's alleged FCRA violation had indeed established a concrete harm sufficient to confer standing, and they adopted a different two-pronged test for concreteness. So the Supreme Court had laid out, this is what we think you need to show for concreteness, and the Ninth Circuit said, yep, we think it's concrete, and then they used a slightly different test. And it was a test that they adopted from something the Second Circuit had come up with. And the two prongs were whether the statutory provision at issue was established to protect the individual's concrete interest as opposed to just a purely procedural right. And if it was, whether the specific procedure violation alleged in that case actually harms or presents a material risk of harm to the interest. And here then the Ninth Circuit concluded, yep, the first prong is easily satisfied. The Fair Credit Reporting Act was obviously established to protect a concrete interest in preventing the dissemination of false information to future employers. And then they said the second prong was also satisfied because the information that Spokeo had gotten wrong was so much more likely to cause harm, right? It was age, marital status, educational background, employment history, than the example that the Supreme Court had cited, which was a zip code. So they reasoned, their holding said, even seemingly flattering inaccuracies can hurt an individual's employment prospects as they may cause the prospective employer to question the applicant's truthfulness or determine that he's overqualified. They concluded then that the alleged FCRA violation was an injury sufficient to confer standing, and they remanded the case back to the district court. Because of course now it has to go back and actually get decided on the merits. So again, just to go back a little bit, we're talking about background screening. This is a case about a consumer reporting agency. Why does this matter if I'm an employer? Well, it does matter. The reason goes back to that damages section, that language allowed under the Fair Credit Reporting Act for willful violations of the Fair Credit Reporting Act. Again, as you know, the Fair Credit Reporting Act places many obligations on background screening companies, CRAs, consumer reporting agencies, as it's called in the FCRA. That's what Spokeo is about, right? But don't forget the Fair Credit Reporting Act places also additional obligations on end users. End users are what the FCRA calls employers, the people that are actually using the consumer reports to make decisions. And what we've just seen that class action litigation has focused on those end user obligations to make disclosures about background screening reports, to keep those disclosures separate from any other document that gets provided to an applicant or candidate in the hiring process. And then we've also seen a really significant focus on class action litigation around the procedural requirements of that multi-step adverse action process that's required by the Fair Credit Reporting Act. That's another set of procedural responsibilities required of the end user, the employer, under the Fair Credit Reporting Act. So what's happened since the Spokeo, since the Ninth Circuit remand, and they're finding that there was standing? Well, of course, Spokeo asked the Supreme Court to reconsider. In December of 2017, Spokeo sought a Supreme Court review of that Ninth Circuit decision in a writ petition. And they said, hey, Supreme Court, the circuits are split. They're already split. And your opinion basically didn't help. That the split was the result of their earlier holding. And then they argued that Supreme Court's review and further guidance was required to sort of stop the widespread confusion over how and when, especially intangible injuries, constitute a concrete harm. The Supreme Court, as you may have heard, denied that petition. They made no comment. There was no discussion about it. That happened in January of this year. And as a result, of course, federal districts and circuit courts remain split on how Spokeo concreteness standards are applied. Thousands of court opinions have cited Spokeo since the decision was entered and amended by the Supreme Court. Thousands. And I wish I could tell you, I wish I could tell you that there was a ton of agreement, either across the circuits or even across the types of statutory violations that are resulting in findings where there is enough information for standing and where there isn't. The circuit splits really range from the manner in which the federal courts apply the degree of risk standard for impending injuries, to the way the concreteness standard is applied, to intangible injuries arising from alleged violation of consumer statutes. These next few slides, I'm sort of identifying what are the circuit splits for those of you who are really interested at the circuit level. And I'm also breaking it out a little bit by the types of laws or statutes that are being interpreted. So Fair Credit Reporting Act is sort of the obvious one for us to focus on for this webinar. And we can see the circuits are split. The 2nd, 4th, 7th, 8th, and the DC Circuit have said that statutory violations of the FCRA without more aren't concrete enough. They don't meet that standard, the standing requirement. While the 3rd and 9th circuits have said the opposite. They say a statutory violation on its own, a procedural violation, is enough to find standing and allow a case to continue. The circuits have also split on who must be injured in order to have standing. So this is a particular interest because most of these cases are being brought as class actions. The 4th, 5th, 7th, 8th, and 11th circuits have interpreted Spokeo to require a showing of actual harm or risk of impending harm to the named plaintiff. So in this, in the example case, it would have been Robbins. Where the 2nd and 3rd circuits only require risk of harm to someone. It doesn't have to necessarily be the named plaintiff. For data breach claims, as you can imagine, there's been a significant activity on this question in the last year or so. And we're seeing the circuits, the 3rd, 6th, 7th, 9th, 11th, the DC circuit, and the federal circuits are holding that victims of personal data theft have suffered a concrete harm just because their personal data is stolen. It doesn't require anything further. Where the 2nd, 4th, and 8th circuits say personal data being stolen isn't enough. There has to be some other additional loss, some other additional harm. what about other federal laws that include a liability clause allowing individuals a private cause of action? There's a number of other federal consumer statutes where we're also seeing a split, right? So not necessarily terribly applicable to the employment context, but certainly interesting as we're watching this test for standing evolve. The Fair Debt Collection Practices Act has seen a split. The Sixth Circuit says more than just a violation is required. At the same time, the 2nd, 8th, and 11th say a violation of that act is enough for standing. The Telephone Consumer Protection Act is another one. The 3rd, 9th, and 11th circuits have held that a violation of the TCPA without more. Nothing more is needed. It satisfies the concreteness requirements of standing. Where a couple of federal districts in the Eastern District of Missouri, the Eastern District of Louisiana, the Western District of Louisiana say something more than just a violation, a procedural violation is required under the TCPA. And then in the context of FACTA, the Fair and Accurate Credit Transaction Act, the 2nd and 7th circuits have held that a bare statutory violation does not satisfy Spokeo's standard for concrete harm, where again, a number of federal district courts here in the Southern District, or I shouldn't say here, but in the Southern District of Florida, the Northern District of Georgia, just a violation is enough. So to put that in some context, which is, so I don't have a table for this in the slides, but even the circuits themselves are splitting on the question of when a violation on its own, a procedural violation on its own is enough to find standing. So for instance, the 6th district, or let's see, what's a good example here? We'll start with the 6th. The 6th district said for a data breach violation or a data breach case, just the violation of the law that resulted in the data breach is enough. But for a FDCPA violation, that something more is required. So the same thing, or the opposite way, the 7th Circuit has said under the Fair Credit Reporting Act, something more than just a violation is required, and under FACTA, something more than just a violation is required. But for a data breach, just the fact that the breach happened is enough. And so not a simple analysis for employers, for companies to go through when trying to identify where their risk is or what they need to plead in the event of a suit being brought in one of these cases. And it's not just the courts, right? We also have regulators and interest groups getting involved. Back on the topic of insulating employers from the FCRA, outside of the Consumer Financial Protection Bureau has been aggressively submitting amicus briefs that incorporate Spokeo since it was decided. So they're using Spokeo. They are interpreting it narrowly, but they are, advising the strategy for groups submitting briefs on behalf of consumers is to allege harm as concrete, right? So part of what they're doing is just changing the language a little bit, right? Where before a procedural violation in the pleadings might have been described as a procedural violation, now a procedural violation is being described itself as concrete harm. And then the National Consumer Law Center, it's a third part, it's an interest group, right? They're recommending that plaintiffs plead actual damages rather than only statutory damages when possible. So interest groups are weighing in on this, and depending upon what side of the interest they're on. They're sort of taking advantage of the sort of vagueness of the concreteness test that the U.S. Supreme Court came out with, and just advising, and I think I would just say plaintiffs are doing a better job of identifying, or in their pleadings, the fact that if it was just merely what used to be merely described as a procedural violation, they're finding or trying to find some way to describe that as a concrete harm or risk. So thoughts for employers. Sorry, it looks like we're at the 30-minute mark, so I will pick this up a little bit. But on the topic of insulating employers from FCRA class action liability, employers should really be thinking about ways to just take procedural violations off the table, right? So look at the Fair Credit Reporting Act. Look at areas where you as an employer have a specific process or procedure that you're supposed to follow, and make sure you've got that process tightened up. Make sure your disclosure and authorization is buttoned up. Make your attack surface small. Look at your disclosure, right? Your FCRA background screening disclosure process. Does that document or does that communication include anything other than the disclosure, the fact that you're going to do a background check, and maybe an authorization? Have you inadvertently combined it with some other notice in your hiring workflow? Look for limitation of liability language. Look for at-will employment language. Look for state disclosure language. Take it all off. Strike it from your disclosure document. Even as recently as a few years ago, as you know, there's the Fair Credit Reporting Act and the requirement to do a disclosure, but then there's also some states that require a disclosure as well. And it was very common for employers to combine that federal disclosure with those state-specific disclosures. Why not make it two separate disclosures, right? That limits your surface area, right? That limits the things that you can be attacked on under the Fair Credit Reporting Act as a procedural violation. Spend some time scrutinizing your adverse action process. Is it a multi-step process, right? Are you actually doing a pre-adverse notification followed by waiting a period of time followed by a final adverse notice? Do the letters or the communications you send, pre and final, include statements and the instructions that are required by the statute? The statute actually lays out a lot of what needs to be in those letters. Are you including a copy of the report with your pre-adverse action notice? Are you including a summary of rights document with both notices? And then, so you'll do all this work to make sure your forms are up to date, to make sure your letters are up to date. Don't forget to train, right? Take a look at your training. Have your recruiters and hiring managers been trained about how to communicate with your applicants during the background screening and pre-adverse action process, right? If you have hiring managers that are, looking at a background check, withdrawing the offer, and then sending out the pre-adverse action letter, that's going to be problematic, right? That's going to be an area where someone might look at that and say, that seems like an FCRA procedural issue. So look at your processes. And then be aware and reveal your policies and procedures for possible violations of other consumer protection laws as well, right? Procedural violations of statutory rights that protect privacy interests are more likely to result in Article 3 standing with nothing else. Data breaches, we can tell, of sensitive information that can be used for fraud or identity theft are likely to result in Article 3 standing. And I think we'll just continue to see plaintiffs continue to push the limits of concreteness of injury for statutory violations. The other thing, of course, as we look at the split with circuits, is expect forum shopping, right? This goes back to the plaintiffs looking for a friendly district. They're looking for places where their case won't get kicked out because of an issue with standing. And then finally, keep in mind, our discussions today have been around cases brought or removed to federal district courts because the FCRA is a federal law. There's a number of states that allow for a private cause of action under state law. They might have similar consumer protection laws, and without standing pursue a federal claim in federal court, a consumer might try to assert a claim in state court, right? So Think about that, because after all, Article 3 isn't about whether you're allowed to file suit, it's about where that suit can be heard. And state courts aren't constrained by Article 3 requirements for standing. State standing requirements could be less demanding. So that's what I was planning to cover today. Suzanne, do we have any questions? Do we need to wrap up?
We are towards the end of our time, but we do have a question through the chat, Heidi. The question states, we use Orange Tree's Candidate Connect both for making disclosures and getting authorization. Should we be looking at that as part of our review process?
Sure. So the answer to that is, of course, yes, right? Like, or at Orange Tree, we built our Candidate Connect system to comply with state and federal law. But we do it, ultimately the disclosure process is the responsibility under the Fair Credit Report of the employer and user. So do scrutinize it, right? We do allow employers to configure and edit the disclosure that we provide to your candidates through Candidate Connect. So if you haven't lately, it might be time to take a look at that. Again, we continuously review the standard language that we have in our template disclosure and authorization forms, but you will notice if you step through the Candidate Connect process, the disclosure is separate from the authorization form. The state-specific disclosures are separate from the federal disclosure. We're taking these sorts of things into consideration when we send your candidates through the Candidate Connect system for the disclosure and authorization process.
Okay, thank you, Heidi.
So I think that, go ahead, Suzanne.
Oh, go ahead, Heidi.
I just was going to say, probably we should wrap up. We do have contact information on this last slide. If you want to continue the conversation, if you have questions or follow-up questions, feel free to send a email to that info@oats.com email address.
Thank you for joining, everyone. The recorded presentation will be available after the fact, and we thank you for your time today. Thanks, Heidi.
Thank you.